Thank you everyone for joining us today for the biggest legal and business, the biggest legal and financial mistakes that business owners make. Today I have with me Noor Al-Masri, who's an accountant. She's been practicing since 2003 in both profit and nonprofit sectors. And I'm so happy to have her with me. And of course, I will be talking about the legal business mistakes that business owners make. And if you don't know me already, I'm attorney Danya Shakfeh. I've been practicing business law for over 10 years. And we'll just get into it. And here we go. So I'm going to share my screen so that everyone can see our slides. All right. Okay, so as I said, this is the title of this presentation is the biggest legal and financial mistakes that business owners make, and I will be doing the legal aspect, and then Noora afterwards will have her presentation about the biggest financial mistakes that business owners make. So the first mistake is not having a proper business setup. And it really is about having a proper corporation. And sometimes, business owners choose the wrong entity. And I will talk about the different types of entities. But first, when we talk about business, what is a business? There are different types of ways that you can have one. First, you might have heard you can be a sole proprietor, which is you don't have a corporation and you're individual doing your business, and your finances are they are the same as your business. Your personal business finances are the same. You don't really operate you personally do not operate separately from your business, and that's called a sole proprietor. Most sole proprietors have something called an assumed name, and that depends on your jurisdiction. Some counties actually require that if you have a business that's non-incorporated, you get it, what's known as a DBA, which stands for doing business as, and it's also known as assumed name. And again, this will depend on your jurisdiction, and it's just really a name for your business. You can't say corporation or LLC in that situation because you're not a corporation or an LLC. And there's no liability protections, and the tax benefits are very limited. And I know Noora can talk more about that when we get to that section. And of course, lastly, is having a corporate entity. And this is probably most, people mostly do this, but I've seen a lot of businesses who have been in practice for a very long time, who actually don't have a corporate entity. So those are 3 different ways that you can have a business. And again, the first mistake is not having the proper business set up. Like I said, to not incorporate at all means that you will that your personal assets will be open to creditors. So for example, if you have a building and then a customer comes into your building, falls and gets hurt, then you could personally be liable in the event that customer sues you, and they could go after your personal assets. But if you have a corporation, you can actually separate your personal and your business assets so that the customer can only attach to the corporate assets. Another mistake is choosing an LLC instead of a corporation, or a corporation instead of an LLC. It's a very personal decision that you make with your attorney and your accountant, because there are legal and financial ramifications for each choice. So that's that first mistake. And as I said before, the benefits of incorporating instead of being a sole proprietor is that you get liability protection. There are, but if you are a professional, you do not get malpractice protection, but all other types of protections you do get. And then of course there are the financial benefits, as I said, like asset protection, and you also can build your own credit because you get a separate tax, you get a separate tax ID, and over time you can use that to get a line of credit, or another type of business loan. Lastly, to get a corporation, the last benefit is that people just see you as a more credible business. They take you more seriously. And if you ever want to sell your business, it's easier because because the business is a separate entity. It's not attached to your personal assets. And of course, if you ever want to grow, it's also easier because your business assets are separate from your personal assets. So what are the types of entities? If you want to choose a corporation, if you want to choose the right type of entity, it's good to have an idea of the 3 types of entities. The first one is a limited liability partnership, or an LLP. They're not used as commonly anymore because the protections are not the same as corporations, and also the tax advantages are not the same, but it's still an option. But most commonly, you'll see businesses use corporations or LLCs, and I'll explain the differences between the two. So corporations, they are governed by the Business Corporation Act of 1983. I'm not going to get into too much, into detail about the statute, but a lot of people confuse what the names of the owners of each type of entity. So in a corporation, the owners are called shareholders, and corporation has bylaws, and they have the shareholder agreements. These are the documents that govern a corporation. The ownership units, they're called shares. So I have a lot of business owners who have LLCs. They come to me and say, well, so-and-so has X amount of shares, but shares actually only apply to corporations, not to LLCs. And I'll talk more about that when I get to the LLCs. The benefits of a corporation is that it's generally good if you want to have outside investors, and it's designed to spread the control and the accountability of the owners, because because you have officer, board of directors, and so there's more spreading of liability and decision making, whereas an LLC is more of like a partnerships, and they tend to be smaller. The cons of a corporation is that you have more corporate formalities, meaning that you have to follow more rules if you want to keep the protections of the corporation. As I said before, if you have a corporation, then you have the asset protection in the event of a lawsuit of some sort. And you could also be subject to like double taxation in the corporate setting, just depending on how you set that up. And of course, if you have an accountant like Nora, she can tell you how not to be double taxed. There are ways for that as well. So the corporate structure, like I said, it's designed for a lot of people to be involved. It's not really designed for one or two people. So you have the shareholders who own the shares. The shareholders appoint the board of directors. The board of directors appoint the officers. The officers report to the board of directors, and then the board of directors are accountable to the shareholders. So you can see, if you have just 2 people, then you're kind of just being accountable to yourself, or like voting for yourself, and it's just not, you can see it's just not, conducive to, just 1 or 2 people. So when you're choosing a corporation, you want to keep that in mind. And of course, you talk to, your professionals to get the right type of corporation. Now, partnerships, this is a little bit more, so like if you're a smaller group of people where you want to put the control more closely into, like with less people, more of a partnership style, then you could get a partnership. There are different types of partnerships. Again, I'm not going to go too much into detail, but obviously the owners of a partnership are called partners, and the the governing agreement is called a partnership agreement. Not legally required though, but it's better always to have one. The ownership units are actually called equity. So you could say I own equity in the partnership. It's not shares. The pros of partnerships is that it's a less complicated structure. You don't have, like the board of directors and shareholders nominating this and doing all that. So and then there are ways to have some protection, but it's not as much as a corporation or an LLC. And the cons of a partnership, again, not as much protection, and you have a lot less tax flexibility. Now, in about 1993, Illinois actually adopted something called a limited liability company, which is basically a merger of corporations and partnerships into an LLC. So basically, an LLC is a corporation partnership hybrid. And they are probably my favorite corporate entities. They're kind of my go-to in most instances, especially for smaller businesses. They are governed by the Limited Liability Act. The owners are called members, again, not shareholders, not partners, but they're actually called members. And the governing agreement is called an operating agreement. So sometimes, business owners come to me, they have an LLC and they say, well, here's our contract between, the partners, the members of the LLC, and it's not called an operating agreement. I've seen all types of wrong contracts. So if you want to have the proper document, it's going to be called an operating agreement, and there are certain elements to an operating agreement. And the ownership units are called interest. The pros, there's a lot of pros. Basically, you can tailor an LLC to almost any way that you want, which is wonderful if you know what you're doing. A lot more tax flexibility. The cons is, the LLC is mostly that it's not that great if you are looking for outside investors. You have to know what you're doing, like to set it up properly. But if you're looking for like venture capitalists, probably a corporation might be more suitable. But otherwise, generally, LLCs can work in pretty much any situation. And there's two types of LLCs. There's manager managed and member managed, and it just really depends on how you want to structure your business, which members have a certain amount of authority. If you have a silence, like business partner versus someone who's active in the business, you can choose between the two. And so, it's like just going back to the mistakes is basically that you have to have some level of understanding of corporate structure so that when you start a business, you have you don't just say, okay, I'm going to have a corporation and then not knowing that there are other options. Now, one common mistake too is that a lot of business owners don't know this concept of corporate veil. As I said before, when you have a business, you have a corporation or an LLC, you get asset protection. And that asset protection is contingent on you following something called corporate formalities. So typically, corporate formalities mean that you have that you separate your business financials and your personal financials. So, don't buy your car on your business credit, for example, or don't, go, on a shopping spree for personal goods, on your business credit card. A lot of people do that thinking, that you can just expense it. But not only is that a tax problem, it could actually create a legal problem. Also, having the right documents, that's also a corporate formality that you need to follow. And just really, at the crux of it is that you're treating the corporate entity as a separate person, because that's really how the law sees corporations and LLCs, as people. And lastly, if you want to register your corporation, you actually go to hybriddriveillinois.com and you can do the registration for it. The actual filing is easy, but choosing the right entity is where you should get a professional. And again, I recommend both an attorney and an accountant. Mistake number 2 is creating the incorrect partnership documents, and that leads to disputes. So, like I said before, there are different types of documents for different types of entities. And, I had one time someone came to me and they were an LLC and they had a dispute, but they had something called an equity agreement, and that was the wrong type of document. And the reason why it's wrong is not just because of the title, but it didn't address all of the possibilities and the rights and the duties of the actual entity. In other words, so if you're an LLC, there's different rules about, what authority, members have. But when you have just this one-page document about you split the assets, you don't talk about how you're going to share your profit and losses, what happens if someone is married or divorced or passes away. And if it's if it's member managed or manager managed, if that's not all in there, you're going to end up having a dispute, and it's going to be very hard to resolve that dispute. So that's why it's very important to have the right kind of documents and just to really get to get a good understanding of what your business structure is. Another mistake is sometimes people don't even have documents. I know that might be hard to believe, but they go into business, they're excited, and and that's totally understandable. You might go into business with someone that you have known for a long time, maybe like an old, college roommate, and that you really trust this person. You think you don't need to have anything in writing. And those are the worst cases, because there was so much trust and now people feel so hurt and they don't have anything in writing about how they were to like do business, and it ends up becoming a he said, she said type of battle. And then another mistake is not using an attorney. And I know that sounds really self-serving coming from an attorney, but the reality is, like any of our, being a professional, like whether you are a mechanic or a painter, a doctor or a lawyer, a teacher, whatever it is, we all have our expertise, and asking someone to come and help you with something that you don't have any experience with, you're always going to gain that benefit. And trying to do it on your own, you don't have that experience. So I do always recommend that you use both like an attorney and an accountant. And just I really want to drive home the point that when you form a business, it's really more than just, oh, I'm going to fill out these documents, or I'm going to fill out these papers. It really is, I mean, like there's a strategy behind it. There's choosing the right entity, making sure that everybody has their rights and roles clearly spelled out in the right kind of document. Another mistake too is when people go into business, they don't outline the actual category of the monies that they put into the business. So like they say, okay, I'm just going to give $20,000 for my business, and then my business partner, Nura, she's going to throw in $20,000. Now we have $40,000, and it's not clear whether it's an investment and a loan. And there is I mean, these like differences are very important, because when you have an investment, you won't see that money back if if the business does not grow, or if the company is dissolved. I mean, that investment, it's a risk, and loans are risks too, but loan, you can still kind of call back, and you can try to attach it to, like as a judgment, or if there's a bankruptcy, like a creditor, like, someone who has a loan, or that gave a loan, can still try to, recuperate those funds legally. And so like if you go into business with someone, or even into your own business, so just by yourself, if you categorize it as a loan, it has to be clear. And you can do both. Like I could be a business owner and say, okay, I'm going to put $10,000 as an investment, $10,000 as a loan. I could do that even though I'm an owner. I can loan money to my business. Because what happens that you have these disputes, and someone will say, well, so-and-so stole this money from business, or whatever, or however they characterize those disputes. But if it's an investment, you really don't, you can't, I wouldn't bet on, expecting that money back, versus a loan, you can kind of claim it. Also with compensation is, that's another, mistake that I see a lot, with a lot of business owners, specifically when one business owner is doing a lot more work. So they say, so like if you have two people going into business, and they say, we're going to split the profits 50-50, and one business owner is doing, 80% of the work, and still being paid the same as the partner who's doing 20% of the work, that creates a huge problem. And so what you can do in an LLC and a partnership is you can have profit sharing and wages and draws. I think people just see profit sharing, and they don't see that there are other ways to actually, compensate yourself for the work that you do. And I think Nora might touch upon that later, in her presentation. But it's very important to understand that as a business owner, there are multiple ways to compensate yourself, especially if you're doing business with someone else, so that you don't end up in a situation where, like you're fighting with your business partner about who's getting paid what. And it's a very joint discussion between an attorney and accountant. I mean, you really can't do it with just one. The third mistake that I see a lot is with not understanding contracts. So it's important for us to know, well, what a contract is. You have offer and acceptance and consideration. Those are the three elements of a contract. It's very important to note that intent is not an element or not. So you can enter into a contract without really intending to, or knowing that you've entered into a contract. So that's very important when you are entering into a business relationship. You can't really say, oh, I signed this document, but I didn't know what I was signing. That's not a defense or an excuse to not following a contract. And all business, partnership agreements, those are all types of contracts. So the first contract myth is something called a standard term. So as with, business owners, like we hear this term a lot, like, oh, this is standard, just sign it, this is standard. But what like business owners need to know is that contracts can be freely negotiated, and to make the distinction between a standard legal term versus an industry norm. So you might have common practices. That's, I think, what people actually mean when they say this is standard, like, everyone in the industry does this, but that doesn't mean that it's legally required. There are some you do have some exceptions to that, but 95% of contract terms can be negotiated legally. And the harm here is that people end up losing rights when they think that they can't negotiate their contract. The second contract myth is to believe that all contracts are enforceable. That's actually not true. Like, some people might say, well, so-and-so signed the contract, so now I'm going to sue you and we're going to go to court and I'm going to have my day. That's not true. So first, it must be understood that if you want to enforce a contract, you actually have to go to court. That's really the only way that you can have a contract enforced. It's through a court order. And in order for a court to give that order to enforce a contract, the contract must be legally compliant and the court must agree with the language. So if your contract is vague or doesn't make sense, or it violates the law, court will not enforce it. And so it's really important. So two common examples of a non-enforceable term are like no oral modification clause. Mostly, not always, there are some exceptions, but when a contract says that this contract can only be modified in writing, in Illinois, that's not always enforced. You can actually modify a contract orally, even though the contract says that it can only be modified in writing. So that's something to be careful about. And of course, non-compete clauses are not always enforceable. There are certain rules that you have to follow to have an enforceable non-compete. So so the common mistake really here that business owners make is to not to think that their contract is just going to work just because they have it on paper and the parties have signed it. Lastly, I want to talk about the biggest negotiation mistakes when it comes to contracts and doing business. Negotiating a contract while doing business is a recipe for litigation. What I mean is that sometimes the parties say, okay, we're going to do business together, but we did not agree, for example, on the price, who was responsible for what, and like all these other terms, but they start selling to each other anyway. So they're still negotiating, but also doing business. So if that contract is not ultimately signed, you can't necessarily just walk away and say, well, we never signed the contract, because your actions are saying the opposite of what the contract negotiation is. So that is still potential for a lawsuit. So it's important that you either are negotiating or you're doing business. You can't really do both at the same time. I mean, you can, but not without, the risk. So at least know the risk when you do that. And so that's really important to have, a lawyer come in and say, okay, here's kind of where you draw that line between, doing business and negotiation and where that risk falls.